Hi, everyone. Good evening, good morning, good afternoon to all of you that are dialing in from various parts of the globe. Thank you so much for attending this webinar. Let's take stock of where we are at the moment. Today is the 14th of May, 2026, and we are exactly 75 days into the conflict in Iran and in the Middle East. Call it what you want, the illegal attack by Israel and the United States upon Iran, the Hormuz crisis, the Bab el-Mandab crisis. It has various names depending on what perspective we're looking at. But the fact is that we're 75 days into a situation that was described 2 weeks ago while I was at the FT Commodities Summit in Lausanne in Switzerland. Russell Hardy, the CEO of Vitol, described the current energy shock that the industry is seeing as the worst shock that he's seen in his career. Now, if somebody of Russell Hardy's vintage is describing this as a significant energy shock, then and all of us need to sit up and take notice and consider what comes next. We've talked about ad nauseum about what's come to pass so far. Some of you attended our webinar that we conducted 2 weeks ago in relation to force majeure, where we revised some of the lessons that we had dispensed in relation to force majeure situations for our audience. And we had promised you that we would talk about what's coming next, what's coming around the corner. And that's precisely what we have on the agenda for today. If you've been in the industry in the last 75 days, surely you've seen the consequences of the physical molecule getting held up in global supply chains. Surely all of you in the audience are now familiar with the concept of force majeure. You're familiar with material adverse circumstances clauses, and you're familiar now with the consequences upon your respective businesses of the failure to be able to move freight or underlying commodities. Now, the consequences of all of that isn't news to anybody that's been paying attention. Obviously, if a physical molecule gets held up, it has knock-on effects upon your ability to perform your obligations in your physical contracts. But that's not what we're here to talk about today. That's already yesterday's news, ladies and gentlemen. The purpose of this session is to sort of look at our radar, look at what's around the corner, and what's about to come. Now, what's transpired in the last 75 days will inform what's about to come. So let's talk a little bit about what's happened. You've had the Strait of Hormuz effectively closed to commercial traffic. You've had a blockade imposed by the IRGC. You've had a counter blockade imposed by the United States and their meager allies. You've had something like 500 million barrels of crude taken out of the global system. You've had global fuel shortages. We've seen shortages in relation to essential commodities like aluminium. We've seen shortages in relation to phosphates because cargoes can't move out of the Middle East. And we're on the cusp of a major food crisis within the Middle East because food cargoes can't reach into the Middle East from west of the Hormuz. So there's a lot that's going on. Now, in the midst of all of this, as a disputes lawyer, I would obviously expect to see disputes in relation to the physical movement of commodities and freight. That's obvious, and that is what we have seen. Over the last 75 days, our team has been instructed in something like $1 billion worth of disputes across the international trade ecosystem. But what we've been seeing hasn't been restricted to merely interruptions in physical supply chains. In the last 75 days, we've also provided our clients key advice in relation to defaults on derivative contracts. We've provided clients advice in relation to damages outcomes on account of hedging situations. We've advised our clients on trade credit defaults as well. And that, ladies and gentlemen, is what we're likely to see a lot more of as this situation persists. As I speak, Donald Trump and his delegation are in Beijing. They are speaking with Xi Jinping and the Chinese government. And we had been told in the weeks preceding this meeting that Donald Trump would not want to be in China and negotiating from a position of weakness. He would want an outcome in Iran before heading out for Beijing. And that outcome hasn't been achieved. And everyone that I speak to on the analyst side has been talking about legislating for a long war scenario. And if we are legislating for a long war scenario, then, ladies and gentlemen, force majeure is already yesterday's news. And we need to start looking at what we can expect going forward. And what we can expect going forward will be defaults across the entire international trade ecosystem regardless of what the nature of the underlying asset that you're trading is. So today, if you're trading oil, you've obviously been affected by this crisis. If you're trading agricultural cargoes that are inbound into the Middle East, you've obviously been affected by this. If you're a ship owner and you have tonnage stuck in the Middle East, you're obviously affected by this situation. But moving forward, what we're going to see on account of the seriousness of this situation is defaults across the entire global ecosystem, irrespective of commodity classes. So look, whether you're trading freight, whether you're trading physical commodities, whether you're trading real estate, debt, whether you're trading loans, whether you're trading Bitcoin, you are going to find that you need to be prepared that some of the trades that you negotiated more than 75 days ago are now no longer in the money, and your counterparties have an active economic incentive to commit default. Alternatively, you might be a counterparty that's affected by these events. You might look at a contract that you negotiated more than 75 days ago, and you might say to yourself, hang on a second, is there any way that I can be relieved from these obligations because I simply can't perform this contract is now out of the money. So in summary, ladies and gentlemen, what we are going to start seeing over the next, and I was talking to a veteran banker just yesterday, and the view that he shared with me was, Sumeet, we're going to see this around the July-August period. We haven't seen anything spectacularly blow up in a public fashion just yet. But July, August is around the time when we're going to start seeing that. And we thought that we'd like to get ahead of the curve, and we'd like to start speaking to our clients right now about the preparations that they need to make for these events that might be forthcoming. Of course, if the situation gets resolved, if trading resumes, we might find a slightly softer landing that we're expecting. But again, ladies and gentlemen, I can't emphasize this enough. 500 million barrels of crude have been taken out of the global system. Crude, which is refined into petrochemical products, affects every aspect of human endeavor. Those barrels are not coming back into the system. And so even if peace were to break out in the Ukraine, in Iran, in the Yemen tomorrow, markets would still feel the reverberations of this crisis for many, many months and years to come. And those reverberations will not be restricted just to physical commodities. Those reverberations will be felt well beyond the physical commodities world. And let me illustrate to you why that is the case. Take, for example, a situation where you have a global crisis of this nature, and you suddenly have a mad rush to be able to corner liquidity. And we saw that in the beginning days of the Hormuz crisis. All of the largest traders in the world went out and enhanced their liquidity profiles and obtained a hugely enhanced degree of credit in order to be able to service their existing debt and their future obligations. Now, the thing is, if you're in a certain position within the market, credit is a zero-sum game for you. Because credit that's been swallowed up by the big boys like the Vitols, Traffys, and Glencores of the world might not be available to you unless you're a super major or a national oil company. In that case, a crisis that doesn't affect you directly may wind up affecting you indirectly because you don't have sufficient credit available in order to be able to satisfy your debt. And ladies and gentlemen, this is something that I'd like all of you to take away from this particular session. And you heard it first over here. And I want you to call me up a year from now and say, Sumeet, you called it. When COVID first broke out, I still remember I was on a bus heading to the airport in Hokkaido after a ski vacation. The airport was empty. We were the only people on the bus. The entire island had come to a standstill. And we were taking this last flight out to Singapore before the world shut down. And I remember thinking at that point in time, I'm very sure we're going to see a wave of commodity crises, commodity defaults, and we're going to see a real crisis in trade finance going forward if this persists for any length of time. And sure enough, it was that event that led to a number of the commodity crises that have roiled our industry since, and that dispute lawyers have worked on over the last 6 to 7 years. Now, long-term commodity trades, they're designed for certainty. They're designed to create optionality. They're designed to to assist parties in the management of risk. But these long-term obligations come under particular scrutiny when economic circumstances are such that the economics of the transaction no longer make sense. We're in exactly such a crisis, ladies and gentlemen, and I'm calling it now. We are going to see major credit defaults going forward across commodity classes and across asset classes. This entire crisis, we've described it, and the press has described it as an oil crisis, an energy crisis. It is far beyond that. And if you've got long-term relationships with your suppliers, with your buyers, or with your lenders, what you want to start doing right now, and that's right, the center of this slide over here, is start stress testing your contracts right now. Start picking up the phone to your lawyers and your solicitors, engage them, engage your internal operations teams and your trading teams to talk about and identify which of your counterparties will not survive this crisis. Which of your contracts will be so far out of the money that your counterparties will be actively incentivized to commit default in relation to those contracts, and ensure that you're prepared for when those defaults eventually manifest themselves. So, ladies and gentlemen, crises aren't agnostic. Crises punish the imprudent. This is your opportunity to stress test your long-term contracts, and I would urge our audience, if you aren't already paying attention to this aspect of your business, you need to start doing so right away. The reason I say this is because for the last 75 days, we've all been focused upon force majeure, material adverse circumstances clauses, and the inability to perform certain individual discrete contractual obligations. And that's fine. That is exactly what we were required to do in the last 75 days. We were required to perform a firefighting exercise. But with some of those fires now under control, with force majeure now receding in the rearview mirror, because after all, force majeure used to be an unanticipated event, right? Now, at this stage, 75 days into the conflict, it's going to be very hard for any trader to take the position that when I entered into this particular trade in the last 10 or 15 days, I did not anticipate that I wouldn't be able to perform on account of what's happening in the Persian Gulf. Instead now of focusing upon that firefighting for which time has passed, I strongly recommend that everyone listening into this conference, to this seminar, ensures that they turn to the future and start looking at what's about to come around the corner. And what's about to come around the corner, ladies and gentlemen, is a wave of commodity and international trade defaults and eventually trade finance defaults that are an inevitability in the midst of a crisis of this nature. So the purpose of this particular webinar is to assist you in preparing for this real crisis that is about to come. If you thought that the crisis was the one that we were fighting for the past 75 days, I'm afraid you're wrong. The real crisis is before us and is about to manifest. And we're here today to walk you through certain precautions that you can take in order to be able to prepare yourself well in time to deal with those consequences. So let's get right into the topic. Let's talk about what it is that you can do if you're expecting a wave of defaults across your trading ecosystem. How can you prepare for that? Now, when you look at, in particular, at long-term obligations are designed to soften market risk. They're designed to create optionality, and they're designed to ensure that value can be derived for a longer period of time than in spot contracts. Now, when building in that optionality, when building in that operational flexibility, when building in the ability to perform notwithstanding extenuating circumstances, which is the hallmark of all long-term contracts, parties often fall foul of defining clarity in relation to obligations. And so the first line of defense, ladies and gentlemen, to any long-term commodity trading default, to any long-term trade default, or any long-term trade finance default, is to ensure that you have preciseness and clarity in relation to the obligations of the parties in the underlying contracts that were drafted at the outset. And so your first line of defense, when confronted with a situation of this character, is to ensure that all of your contracts are drafted in a manner that will safeguard your interests in the event circumstances change. And the first step in that is ensuring clarity and certainty. So ensure that your contracts have certainty in relation to pricing, volumes, lifting obligations, shipment obligations, and so on. Simultaneously, while you ensure that that preciseness exists, ensure that you built in sufficient operational flexibility to ensure that neither of the parties has an incentive to commit an outright default, but rather that both parties are incentivized to ensure that they continue to perform by alternative means, by providing for, say, sourcing or destination flexibility, by providing for pricing revision clauses, and so on, in order to be able to keep the commercial enterprise, the engine of that commercial enterprise that earns revenue, still running. So two things to keep in mind, ladies and gentlemen. Three things to keep in mind, actually. Firstly, the first line of defense against a long-term commodity default is sensible drafting right at the outset. When you're engaging in a drafting exercise, ensure that you balance clarity and certainty with flexibility. If you have clarity and certainty, your obligations will be enforceable, as will be those of your counterparties. If you retain operational flexibility without sacrificing clarity, you create a commercial incentive for the continuation of that commercial enterprise. Now, while doing so, while looking at the drafting of your contracts, you also want to take a look at what your security packages look like. Now, so if any of you who were dialing in, and I believe we've got something like 200 odd people dialing in today, if any of you are on a credit team, what you want to be doing is asking your traders, look, 80-20, tell me what are your most crucial long-term trading relationships. Let me dust those contracts off and let me look at the security packages that you obtained in exchange for that long-term commitment. And let me ensure that not only is the underlying contract sufficiently certainly drafted, let me figure out what the triggers of defaults are so that I remain prepared in the event of a default. And finally, let me also look at the security package that we've obtained in order to be able to ascertain that the security package will be enforceable in the event of a default. Now, all of this latter piece, aside from the drafting that I've talked about, is commonly referred to as stress testing. And ladies and gentlemen, as I said, crises only punish the imprudent. Engage in that stress testing exercise now without delay. If you aren't already in the midst of assessing which of your counterparties is going to inevitably commit default as against you, you are already behind the curve. Now, speaking of the defaults themselves, let's talk about when a default occurs and what the background of that default is. And in talking about that, I'll also share a little bit of experience that we've acquired over the last 75 days, specifically dealing with commodity trading in the midst of this crisis. Let's talk about all of that, yeah? So at the outset, in a situation such as the one that we're confronted with, and we saw this is not new. I find it rather amusing when respected publications will talk about the unprecedented nature of this crisis. This crisis, ladies and gentlemen, is not unprecedented. We've lived through the Asian financial crisis, the dot-com crash, the GFC in 2008, COVID-19, the Ukraine war, wildfires in Canada, climate change. Everything that we're seeing today, the legal principles that apply to the situation that we're seeing unfold today were developed over 250 years ago and remain relatively unchanged. And so none of this is unprecedented, none of this is untested, and we've already devised a playbook in relation to the management of these situations. And so let's firstly acknowledge that none of this is new. We've seen all of this before, okay? Now, having said that, you're confronted with a potential default or an outright default. Let's talk about what do you do then? Now, the first piece of advice that I give to my clients whenever they pick up the phone and call me up and say, Sumeet, we've got a default, we'd like to instruct you, can you clear conflicts? After clearing conflicts, the first question that I ask my clients is, look, can you resolve this? Can you work with your counterparty to ensure that this enterprise doesn't come crashing down? And can you keep working with them and see a way to perform, even if that means you taking a bit of a haircut and perhaps them undergoing some amount of financial pain? And that is advice that has been very well taken by a number of our clients over the last 75 days. What we've noticed is that a number of counterparties have been incredibly mature about the performance of obligations in their contracts. And when innocent of any default, parties have worked really, really hard to work with defaulting parties to ensure that performance can continue. Clients have been very reluctant and quite wisely so to call an event of default lest that commercial enterprise come to a crashing halt. Now, that's an excellent thing to do at the outset while the situation is still dynamic. But there comes a time when one needs to establish what one's position is. And so, again, ladies and gentlemen, this is one of the big takeaways from this session. When dealing with a potential default or an actual default, you need to have real clarity in relation to at what point are you going to make your position absolutely clear in black and white terms. Now, negotiation and accommodating a default and working with a defaulting counterparty with a view to ensuring continuing performance is not exclusive of holding your counterparty accountable in writing and expressly. And so while you work with your counterparties to achieve commercial resolutions to the default that you are seeing at the moment, I would urge you to be very, very careful of engaging in conduct that can be construed as forbearance or acceptance of a breach or affirmation of a breach that would then allow the breaching party to escape liability. So while you work with your counterparties, work also with your in-house legal teams, work with your external solicitors to obtain formal legal advice, because what you don't want to do is fail to hold a counterparty accountable for their conduct and thereby sacrifice your ability to pursue them in due course. You don't want to issue that notice of default too late. Okay. Now, why do I say that? Why do I say you don't want to issue that notice of default too late? That is because our entire playbook in relation to the management of long-term commodity trade defaults, and we've tested this playbook. We've done the whole lather, rinse, repeat approach to this entire playbook many times over the last 2.5 decades. And the playbook has always worked. And we found that the starting point of any action is ensuring that you establish liability first. Okay, so we've already segued really neatly into what the strategies are for the management of long-term defaults. Yeah, so let's talk about the first step, which is to hold your counterparty liable, and more importantly, to establish liability. So the first step, what you do is you determine that your counterparty is in default. You're working with them to cure the default and so on. But as a measure of prudence, you go out and instruct your solicitors and say, Sumeet, I'd like you to draft me a notice of default that reserves all of my rights as against the counterparty. At that point in time, any good solicitor would turn to you and say, what you should do is you should get yourselves a merits opinion in relation to what's transpired so that we can establish where in relation to the contract your counterparties committed their breach. The reason we want to do this right now is because we want to make it absolutely clear. It shouldn't be questioned later whether the counterparty was in breach or not. And so we want to ensure that notice of breach, that notice of default goes out as soon as possible. And it sets out without any doubt whatsoever what the grounds are on which you hold your counterparty in breach. I'll give you a really great example of this. At the height of COVID, we were instructed by one of the mining majors in relation to a commodity contract, a long-term commodity contract that they had entered into with a certain manufacturer of a refined product. And the manufacturer of the refined product had decided they didn't want to perform any more offtake from our client on account of the fact that the market had tanked. The market was at its very bottom. They had purchased from our client at very high rates when markets were healthier. And at the height of the COVID crisis, they found that they didn't want to perform that contract anymore. And so they declared force majeure. And the first thing that we did was we broke that force majeure defense that was adopted by our counterparty. And we said, look, we can talk numbers and so on, but the fact is you are liable. This is an FOB contract for shipment from a load port to a discharge port. You're located at the discharge port. You're saying that there is a force majeure event at the discharge port, which we admitted there was. But we said to them, your only obligation as an FOB buyer was to take delivery of the goods by presenting a vessel to load at the load port. You've made no allegations of force majeure at the load port. Therefore, while we appreciate the difficulty that you face, regrettably, you are in breach. We hereby hold you in breach. We will not discuss whether you are in breach or not. All we will discuss with you is the quantum that is payable by you on account of your breach. Now, having adopted that position so strongly right at the outset, we did away with the need to, in that eventual arbitration that transpired, we did away with the need to do 4 days of hearings on whether or not the counterparty was in breach. Going into the arbitral hearing, we already saved our client over $1 million in legal fees by eliminating the needs to cross-examine multiple witnesses and to deal with submissions in relation to whether or not liability existed, because in the run-up to that arbitration, over correspondence, we established without a reasonable doubt that the counterparty was in breach. And so, first big takeaway for this entire session, ladies and gentlemen, when confronted with a potential default in a long-term contract, regardless of asset classes, doesn't matter whether you're in freight, whether you're in hard, soft, whether you're even in commodities, you could be trading loans, you could be trading Bitcoin. If your counterparty is in default, ensure that liability is expressly established right at the outset. Now, some of you who are in the midst of firefighting at the moment and you're working with your counterparties to ensure continued performance might balk at this, and you might say, no, hang on, Sumeet, that's a little bit heavy-handed. I'm working with these guys, they're trying to perform, we're all taking a haircut, we'll somehow get out of this. I completely accept that, but it's really, really important for you to reserve your position. And when working with the defaulting counterparty in a constructive fashion and trying to revive that commercial enterprise in respect of which default occurred, setting your position out expressly will allow you to negotiate from a position of strength. So do not squander that and ensure that you've reserved your position, ensure that you've established liability, and then by all means, on a without prejudice basis, continue to work with your counterparty to see if you can navigate your way out of that particular difficulty. But I can't stress this enough, ladies and gentlemen, establish liability right at the outset. Once you do so, all you need to do then is work on quantum. And that establishing quantum, once breach is established, can be a relatively more inexpensive exercise than having to engage in back and forth with a firm of solicitors in relation to whether liability exists or not. Yeah. Now, the other question that I tend to face every time when I'm confronted with default under a long-term contract is, okay, Sumeet, we've got a default, we've established liability, counterparty is not disputing that, what do? I'd like to terminate the contract, get out of it right now. Got to be really, really careful, ladies and gentlemen. This is the second big takeaway in relation to this session. When you are contemplating the consequences of a breach, you've got to be really, really careful. You might recall how I said the first defense against a breach is a sensibly drafted contract, right? You've got a sensibly drafted contract, you've established a breach, you've established liability, you now want to terminate the contract. Before you do so, go back to the contract itself, that beautifully sensibly drafted contract that you have, refer to it, and ask yourself, how are my obligations expressed? How are my counterparty's obligations expressed? And how is the right to termination expressed in this contract? Or more broadly, how are the consequences of breach expressed in this particular contract? The reason why I say this is because, and again, this is the big takeaway for everyone that's engaged in long-term trading. The mere default in relation to a single shipment or a single obligation under a long-term contract might not amount to repudiation of the entire contract as a whole. Let's make that real. Let's share a war story. The markets have been fairly choppy for the last, ever since the world came back to life after we opened up, after COVID ended. The markets across commodity classes have been incredibly choppy, and we've seen a lot of disputes crop up over the last 4 or 5 years in relation to physical commodity trading. Some of those contracts have involved long-term obligations. We were instructed by a physical commodity trader in relation to a contract that involved, I think, 4 shipments of cargoes. The first shipment went off without a hitch. By the time the second laycan arrived, the contract was out of the money for our client's counterparty, and they sought to default. And so ultimately, 3 out of the 4 shipments weren't performed. When the first default occurred, so when the second shipment wasn't performed, our client wanted to terminate the entire contract because that seems like a logical and intuitive conclusion to arrive at. After all, this is a contract for sale. My counterparty doesn't want to buy the goods that I presented for sale that comply with all of the contractual specifications. If that's the case, he must be repudiating the contract, and I must therefore be entitled to terminate the contract as a whole. And we said to our client, no, don't do that. Because it is trite in English law that a mere isolated breach in the context of a long-term obligation does not allow you to consider the entire long-term obligation discharged. And our advice to this client was, look, your counterparty is defaulted on 1 shipment. And these are monthly shipments. There's no telling what the market will be like when the 3rd and the 4th shipment laycans come up. The market may have risen by then, and they may be incentivized to perform. But regardless of whatever the market reality is, if you terminate the 3rd and the 4th shipments in this contract on the basis that the second shipment has been defaulted on, you might be committing repudiatory breach, because at this time there is no indication whether they will or will not perform the later shipments in the contract. And so we told our client, just because of the breach of 1 shipment, you cannot terminate your obligations in relation to the latter shipments. And if you do so, you will be in breach of your obligations. And so, ladies and gentlemen, this is a really big takeaway. Be very, very cautious when considering what the consequences are of a breach, especially if your instinct is to terminate a long-term contract. And this principle applies across asset classes. This isn't just a shipping or a commodity trading principle. This applies to construction contracts, real estate contracts, to term loans. This will apply to long-term trading of any asset class. Be very, very wary of wrongfully exercising a right of termination in the event of a default of a long-term obligation. Be very careful to take sensible legal advice and ensure that you're not operating on instinct, because in a time like this, and again, I'm going to harken back to some of the discussions that were had in Lausanne a couple of weeks ago. It was, I think, the CFO of Vitol who said in the last 45 days, we've had to wake up every morning and then we get told what our day is going to look like on the basis of Donald Trump's tweets. So what happens is we go to sleep at night after having taken a certain position, knowing full well that we'll have to wake up and potentially reverse that position. And doing that day after day for 45 days has left all of my people exhausted, and exhausted people make mistakes. In the midst of a crisis like this, ladies and gentlemen, it will be very tempting to act on instinct. It will be very tempting to act on emotion. And it is a perfectly instinctive reaction to say, you're in default, I surely am entitled to terminate your contract. That is not how the law works. In order to be able to terminate a long-term contract, you have to demonstrate on a balance of probabilities very strongly that there was a likelihood that your counterparty would not perform their obligations, and you'll have to lead evidence in relation to that proposition. And I haven't yet come across a case where a counterparty, and we saw this, we didn't just see this during COVID, we didn't just see this in the last few years. The first time I dealt with a situation like this was in 2008. And I remember my internal clients, I was an in-house lawyer at Cargill at that point in time, and I remember internal clients being appalled that a long-term charter party could not be terminated on account of the fact that the first, second, and third listings, this was a 25 listing contract, this was a long-term COA, they were appalled that after the first 3 listings had been defaulted upon, we still advised that we could not declare a repudiation of the entire contract. Now, there's a commercial element to this as well. I remember in that discussion when I was in-house lawyer, I did say to my clients, I said that, okay, hang on a second. They defaulted the first shipment. What are your damages for that shipment? Okay, about $2 million, fair enough. Second shipment, another $1 million. Third shipment, maybe slightly less, call it $750. So you're at about, say, $3,750,000, let's call it $4 million. You're at that level of a quantum default on the part of your counterparty. I've spoken with our analysts and our derivatives team, and what they tell me is on the basis of where the market's headed, and the market wasn't heading in a good direction at that point in time. So on the basis of their assessment as of last week, if we were to call a default of this entire contract, you'd have to write an entry into your books of account for something like $400 odd million. Because that was the value of on a mark-to-market basis, when the market was right at its bottom, of all 25 listings. And I asked my internal clients, are you prepared to take that kind of a provision in your books of account? And think about this. If you call a default on the entire contract, not only have you ended your trading relationship with these guys, but you've also gone out and created this liability that you now have to recover. And do you think it's practical for you to recover that sort of a liability from a counterparty that isn't that creditworthy? And so not only on a legal basis, but even on a commercial basis, that there can be real implications to calling a default on a long-term contract. And ladies and gentlemen, these decisions are not for the faint of heart and mustn't be made casually and lightly. So just be very, very careful when confronted with a default, when determining what the consequences of that default are, particularly if you are tempted to exercise your right of termination. So let's very quickly revise. Two quick takeaways that we've discussed so far. Number one, establish liability first. Don't find yourselves in a position where in an arbitration 2 or 3 years down the line, you're still questioning whether your counterparty was liable. Work with your external solicitors to ensure that correspondence is exchanged in order to establish liability beyond any reasonable doubt, so that your claim is transformed from a liability in quantum claim into a quantum claim only. The second quick takeaway was in relation to the consequences of a default itself and your decision to terminate. So the second big takeaway was, ladies and gentlemen, be very prudent when you are tempted to issue a notice of termination. Please ensure that you aren't engaging in repudiatory conduct yourself. There are two more big pieces of this conversation that I want to take up with the limited time that I have. Once you are confronted with a default and you are an innocent party, you are required to mitigate. Let's go back to the last slide. I want to refer to the right side of the last slide. Mitigation in a default situation is not optional. It is mandatory on a common law basis. Subject to the terms of your contract, if you are an innocent party and you're confronted by a default, by a defaulting party, you cannot simply sit on your hands. You do have to take steps to mitigate the effects of the default by the counterparty. Say, for example, long-term contract for the sale of, say, coal to a utility. The utility commits default on account of movement in prices. They don't want to perform the contract anymore. You establish liability, that's fine. Your first shipment laycan comes and goes. What you need to do is that cargo that you had secured as an international trader in order to be able to supply to that utility, you can't simply abandon that cargo. You can't simply do nothing with it. You are required to enter into a mitigation sale. And in entering into that mitigation sale, you must ensure that everything that you do is reasonable. So say, for example, you had a contract with the sale of $100 worth of commodity to a particular buyer. The buyer commits default. You're then required to go out and sell that parcel in the market. What you can't do is sell it to your cousin for $10 if that isn't the true measure of the value of that underlying cargo. What you can't do is abandon the cargo and do nothing. What you need to do is go into the market and seek the best possible price that you can obtain for that particular parcel. And having mitigated your losses, you can only claim those mitigated and reduced losses from your counterparty. Otherwise, if you fail to do that, if you fail to take steps in mitigation, you will be called to account for that in due course. And a court will not award you the full extent of the damages you feel you suffered, but the court will only award you the damages that should be payable had you mitigated your position. And so you want to ensure that you've mitigated your position up front. You've done so reasonably in light of the conditions of the market at that point in time. And most importantly, that you've documented and evidenced all of the steps that you're taking in relation to mitigation, because ladies and gentlemen, I can tell you this with bitter experience, your counterparty who defaulted on the contract will open up and examine with the benefit of hindsight all of the decisions that you took in mitigating the effects of his or her default. Now that sounds really unjust, but that's unfortunately just the way these arbitral proceedings pan out. You make a claim for damages, you say that my counterparty defaulted, I was forced to sell these goods at a discount in a falling market, and therefore I should be given my mark-to-market difference, the distinction between the price that I obtained in a distressed sale versus the contract price of the goods themselves. At that point in time, your counterparty will say, no, hang on a second. Sumeet, I don't agree that your client is entitled to $100 in damages because they sold the goods for just $40. They could have sold it for 60, or they could have sold it for 70, in which case my exposure is limited to just the difference between the contract price and that higher mitigation price. And so in that arbitration, there will ensue a battle of the experts, where market experts will be called in to talk about what the market state was at that point in time and where prices were, in order to evidence the fact that what the innocent party did was reasonable. Similarly, quantum experts will be called in to opine upon the economics of those decisions. And so you've got to ensure that not only have you mitigated, but you've also evidenced your efforts at mitigation really, really carefully in order to ensure that these are admissible in proceedings in due course. Now, while mitigating, there's another thing that you have to just bear in mind. You have to give your counterparty, if possible and if reasonable, an opportunity to perform at that mitigated price as well. And if you do so, you will have achieved what we call a best-in-class mitigation scenario. And if you come to me with an instruction of that nature and you say to me, Sumeet, I was obliged to perform, I was able to perform, I offered to perform, my counterparty defaulted, I then gave them an opportunity to perform again, they continue to default, I then went and mitigated my position. And when mitigating, told them this is the best price I can obtain, can you do better? And they didn't respond. I would say to you that is an excellent case that I'd be delighted to accept. And so let's quickly revise. So far, we've talked about 3 quick takeaways. We've said, number one, in a long-term contract, be really, really wary of circumstances that surround that particular default, and ensure that when you're seized of a matter, be very cautious about your desire to terminate. It may be an instinctive reaction that you feel that you're allowed to terminate, but be very cautious about that. Ensure that you mitigate, and ensure that your steps in relation to mitigation are very carefully documented and evidenced. And this is a really good segue into the last big takeaway that I have for our audience today, which is that evidence determines outcomes. I keep saying to my team that when a matter initially comes to us, we need to act as lawyers. We need to be very cognizant of what the legal position is, and we need to give our clients clear, substantive legal advice. Once the matter proceeds to adjudication, however, we need to stop acting as lawyers and we need to start acting as case managers. And we need to ensure that that case can be won regardless of what the legal position is, because surely by this time we've already established for our clients what the legal position is, and now we want to manage this particular case effectively. And a great hallmark of effective case management is the management of evidence. After all, if you want the sympathy of a tribunal for your cause, what you need to do is give them reasons to support you. And evidence is a crucial part of that reasoning that tribunals and courts apply when adjudicating matters. So for example, you had a long-term contract, your counterparty was in default. Did you evidence that default? Did you issue a notice of default? Did you create contemporaneous evidence to demonstrate that your counterparty wasn't willing to perform? If the answer to that is no, you will be hard-pressed to demonstrate a default in court. If you didn't establish liability at the outset, you will then have to prove liability in court. And finally, if you don't have evidence backing up your efforts at mitigation, a court will be hard-pressed to have any sympathy for your efforts at mitigation. A court will be hard-pressed to hold that you acted reasonably. So ensure that you've got all of the documents and records in relation to the default itself, the events leading up to the default itself, the aftermath of the default, and mitigation efforts that resulted in the crystallization of your losses. And if you've got all of that evidence, you'll be in the strongest possible position that you can be. So those are my big takeaways for this particular session. Let's just do a quick revision of what we've discussed today. The fact is that we are in one of the largest crises that the global system has faced in recent times. All of the legal principles that underpin the management of a situation like this have been developed many hundreds of years ago and remain relatively unchanged. There's nothing unprecedented about this crisis except for its scale. The playbook that has been employed in the past will continue to remain relevant going forward. Let's talk about that little playbook. At the outset, first things first, your first defense against any default in a long-term contract is sensible drafting right at the outset. However, no amount of good drafting can legislate for a change in circumstances, firstly. Secondly, a mere change in economic circumstances that causes a party to breach its obligations is not grounds to forgive that breach. In other words, non-performance driven by economics is still a breach. Yeah. Once a breach has been established, once liability has been established, it's very important to understand that wrongful termination can reverse the legal position entirely. You must be very, very cautious when engaging with your counterparties and exercising the right of termination, particularly in relation to long-term contracts. Mitigation is not optional, it is mandatory. Mitigation is a binding legal obligation. When confronted with a default, you cannot simply sit on your hands. If you're stuck with a cargo in a falling market, you have to dispose of it at fire sale prices. If you are confronted with a default by a supplier in a rising market, you have to obtain goods at a greater expense in the market. What you can't do is simply sit on your hands and claim the entire value of a contract from a counterparty. And finally, evidence wins disputes. Contemporaneous records that establish what happened in the run-up to the default, during the course of the default, and shortly after the default, and in the midst of mitigation, will be the difference between winning and losing the case that you're confronted with. And in the midst of this crisis, ladies and gentlemen, you won't have the headspace or the mental bandwidth to be able to manage the collection of evidence. And so I strongly urge you to ensure that you confer with your trusted solicitors, clear conflicts, have them appointed so that they can assist you in the preservation of evidence. While talking about instructing third parties such as solicitors, and I'll close with this, one of the first things that we did about 75 days ago when our clients, super majors, big oil traders in a national oil company started calling us up and saying there is this situation, the first thing we did was go into the market, and conflicted them out in relation to all of these counterparties that our clients were acting against. Now, the industry is small. There's a limited number of credible people that I would want to place in front of a barrister for cross-examination in relation to a market or in relation to quantum. And in conflicting all of those individuals and getting them on our side, we've ensured that should any of these claims proceed to arbitration, we'll have the best possible team available to be able to present our client's case. And so in a situation like this, when you're dealing with an asset class, say for example, if you're dealing with an asset class like Bitcoin, where experts are few and far between, you'd be very, very well advised to ensure that you've got the right advisors on board right at the outset. And with that, ladies and gentlemen, I'm going to take a quick pause and ask my colleagues how much time we've got left and if we have any questions.
So if anybody has any questions, they can put it on the chat, but maybe I'll kick you off with a question. So if in your experience, when a client is looking at existing long-term contracts and they want to focus on one area which would be pertinent to improve or redraft in this climate, what clause would you look at in the first instance?
That's a great question, Ramti. And unfortunately, I'm going to give you a very loyally answer to that question. The answer to that question is it depends. It really depends on the underlying asset class that you're trading. If the underlying asset class is one that allows for price optionality, I'd say get that in there. If the underlying asset class is such that the asset itself is going to be worthless in the event of a default, I'd say look at your security package and tighten that up. What I would do is I would be cautious about balancing that clarity and flexibility. And rather than identifying a single clause, what I'd identify is a single principle, which is ensure that your contracts have sufficient flexibility so that there's no incentive to commit default, but also ensure that they have sufficient clarity so that your solicitors can go before a tribunal and demand that the contract be clearly enforced.
Understood. Thank you. If there are any further questions from the audience, we can have those in the chat. We have some questions coming in.
Go ahead. We're just waiting for some more questions to come in. I can see the people are typing.
Okay, so what is the most important first step for a party when a counterparty stops performing?
Okay. It's not just one step that you should take when a counterparty stops performing. The first thing that you need to do is you need to take refuge within your own contract. Let's make this real. Let's talk about a real life scenario. You're an in-house lawyer or you're an operator at an international trading company, and your trader comes to you and says, payment was due to be made yesterday. We haven't received payment as yet. It's a potential default. What do? The first thing that you do is you take out the contract itself. You satisfy yourself how the obligations are expressed in that contract. And your trader may come to you and say, we were due to receive $14 million yesterday, but the contract may not say that. And so the first step that I would take is I would look at the contract itself. I would go to somebody sensible who can read contracts, an in-house lawyer or external solicitor, and I'd say, listen, my understanding is that they're in breach. Can you clarify to me that from a legal perspective, they are indeed in breach? And then can you tell me what are the consequences of that breach and what I should do in relation to immediate next steps? And so, that's a long answer to that very good question. What I would say is read the contract, understand how those obligations are expressed, and it'll become very clear to you what the consequences of that breach are and the action that you can take.
Sure. Thank you so much. Another question has just come in. Any tips for lenders? What should they be doing for non-paying clients who finance vessels in the Middle East?
Actually, I have a lot of tips for lenders. One thing that I will say to lenders right now is that we've all been looking at this as a commodity crisis or an energy crisis or a freight crisis. This is not an energy crisis or a freight crisis or a commodity crisis only. It is developing into a capacity crisis. Now, regardless of whether you're a lender, you could even be a trader, and this advice will be relevant to you. You need to know which of your counterparties, your clients, your borrowers have the ability to service their obligations in the future or have the capacity to service their obligations in the future. And so my first tip to anyone who's a lender in this particular presentation is that look at your book and determine which of your counterparties, which of your borrowers are going to be able to service their debt going forward. And on the basis of the economics in your lending documents, it'll become very clear to you which of your assets are about to become non-performing assets going forward. Now, if you are a lender that has financed a delinquent asset that is stuck in the Middle East, all is not lost. The Middle East is still open for business. We've got an office in Dubai. If you've got vessels sitting over there that are funded, it'd be my pleasure to put you in touch with the excellent dispute resolution team that we have down in Dubai, and they can go and secure your claims by arresting those assets where they lie. And the good news is, those assets can't go anywhere. They've probably got the AIS switched off, but we'll find them and we'll secure them for you. So if you are a lender in this situation, do not hesitate to get in touch.
Great. And I think just to wrap the final question, in a situation where the counterparty declares force majeure, but you don't accept their position, particularly where it appears that non-performance is driven by economic factors rather than within the force majeure clause permit, and the counterparty maintains its position, how should we proceed if we want to compel performance? And what practical or legal steps would you recommend in this scenario?
This is a brilliant question. I love this question. You're confronted by a situation where your counterparty declared force majeure, but you said to your counterparty, I don't agree with that. You are perfectly capable of performing. This is price majeure. It has now become more financially onerous for you to perform, and therefore you don't want to perform. And so the questions are, what are my options and how do I compel performance? your options are as follows. The first thing you need to do is you need to make clear to your counterparty what your position is in relation to their force majeure declaration, and you need to hold them in default if they are in breach of their obligations. Now, be careful about doing that, because I may declare force majeure today in relation to a shipment that's due 3 weeks from now. You may not agree with my declaration of force majeure, but you can't hold me in breach today because that shipment only will occur a few weeks from now. So you can't issue that notice of breach just yet. So make sure that you work with an internal solicitor or an external solicitor to be able to manage that entire process. How you can compel performance is to say, look, either you are in breach or you're going to be in breach. This is what I assess my quantum to be. I'm going to incur something like, let's pull out a number. I'm going to incur $60 million on account of your failure to provide that shipment to me by the end of the set range for this particular cargo. Once you make it clear to the counterparty what the consequences will be if they're default, you will find that the conversation is initiated. And parties will come to the table to talk about a potential resolution. Now, if having issued a notice like that, potentially on an international solicitor's letterhead, if a conversation doesn't commence, if your counterparty is not picking up the phone to you and saying, hang on a second, Alankriti, let's talk about this. I saw your message from Watson Farley, and you said $60 million? That's ridiculous. I didn't realize that for one shipment. What's going on? If you don't receive that call, ladies and gentlemen, you need to commence action immediately for the securing of assets and for the securing of your claim in the future, because if you don't receive that call, it says to me, your counterparty is simply not interested in performing. In order to compel performance, another option that might be available might be enforcement of a security package, but we don't usually see security packages in long-term commodity contracts unless those contracts have a financing element. But we can talk about that in a separate session as well.
Great, thank you. I think those are all the questions we have, and
amazing.
Thank you for closing remarks.
Thank you so much for that, Lakshmi. I thought those were great questions. I want to say thank you so much to this excellent audience for your engagement. Thank you so much for turning up and listening, and thank you so much for your excellent questions. I'm really embarrassed by the fact that my photo is on the screen, so I'm going to switch back to the beginning of the presentation and leave you with that. But ladies and gentlemen, thank you all for your time. This was an exercise in seeing what's coming around the corner. Hopefully this was useful. A year and a half ago, my firm's management came to me and said, Sumeet, what's going to happen in the next year? And I said, they're going to see a major black swan event. Let's do some content on force majeure. So we put that content out a year and a half ago. Here we are today talking to you about what's about to come. And I hope that the session was really useful. And let's keep the conversation going. Thank you all very much for your time. Bye now.